Hi, with me Ms. Bwalya. In today's lesson, we'll look at Unit 1 of Business Law. So Unit 1 of Business Law, these are the contents that in Unit 1, we'll look at contracts. We'll define what a contract is. Then we look at the essentials of a contract, which include an offer, acceptance, intention to create legal relation, as well as consideration. Then we'll also look at the factors that affect terms of a contract, which include duress, undue influence, misrepresentation, as well as mistake. Okay, so we'll start by defining what business law is. We'll start by defining what business law is. So the term law, okay, we'll start with law. The term law is generally used to refer to a body of rules or standards that are intended to define acceptable conduct from that which is not acceptable. So the word law generally, it is used to refer to that body of rules that are set up or those standards which are put in place for the purpose of defining what acceptable conduct or acceptable behavior is from that which is not acceptable. For instance, in an institution, they might put up some laws which will stand as rules as well as standards to be followed in that organization to differentiate which behavior is accepted in that organization from that which is not acceptable. So according to Salmond, law is defined as it consists of any principle which is recognized and enforced by the courts in the administration of justice. Okay, now let us define what business law is. Business law is a systematized set of predominantly dispositive legal norms that regulate property relations of professional transfer of assets aimed at selling and purchasing exchange values of goods rather than their utility. Okay, so that is the definition for business law. Now let us look at Zambia's sources of law. Zambia's sources of law. So Zambia's sources of law, when we say sources of law, what we mean, it's the ways in which law can be brought about into existence. Okay, so the sources of law in Zambia include African customary law, the English common law, and principle of equity, Zambian legal precedents, legislation, and international agreements. Okay, so those are the sources of law that we have in Zambia. Then let us look at what a contract is now. So we're defining a contract. A contract is a legally enforceable promise or set of promises made by one party to another. So those legally enforceable promises that let's say an individual makes to another individual, that is what a contract is. And that promise made should be legally enforceable, okay, for it to qualify to be a contract in short. A contract is a legal binding agreement concerning a bargain which is essentially commercial in its nature and involves the sale or hire of commodities such as goods, services, or land. So when we hear contract, mostly what we think is that it is only about sale of commodities, of goods, or for services rendered. But here we learn to say contract can also involve not only the sale but also hire of commodities such as goods, services, or land. So it is not only about sale, but also when hiring, contracts can be put in place. Okay. Let us now look at the elements of a contract. So number one, we have offer. Number two, we have acceptance. Number three, intention to create legal relationship, which is also known as a contractual relationship. Then number four, we have consideration, and lastly, form. Okay, so we'll look at these one by one in detail. Offer. An offer is an expression of willingness to contract on a specific set of terms made by the offerer with the intention that if the offer is accepted, he or she will be bound by the contract. Okay, so the offerer here is the person who makes an offer. Then we have the offeree, who is the person or individual. It's not only individuals that are involved in contracts, so we can say to whom the offer is made. Okay, so that is what an offer is. It is an expression of willingness to contract on a specific set of terms made by the offerer with the intention that if the offer is accepted, he or she will be bound by the contract. So an offer may be expressed by words or it can be implied by conduct. An offer can be addressed either to a single individual, a specified group of people, or to the world at large. Some offers you may find that they're only directed to a single individual. Okay, then there are some offers that are directed to a specific group of people. Okay, then there are some offers that are directed to the world at large. I'll give an example of an advert. An advert can be made just to a specific person. It can be made to a specific group of people to say, okay, this is suitable, let's say, to children. That is an offer that is made to a specific group of people, which is the children. Then there are offers that are made to the world at large. Like, for instance, if in an advert it is stated that this is suitable for any individual, okay, be it children, be it adults, or age groups, in short, okay. Then the termination of an offer. How can an offer be terminated? The termination of an offer. How can an offer be terminated? Number one, we have the lapse of time. So when time passes, an offer can be terminated. I'll give an example of a job vacancy. Let's say a job vacancy is advertised, and then in that advert, they say applications should be forwarded, and then they put a due date um, on that advertisement that is made for the job offer. So when that time passes, that means that offer for a job advert is over. Okay, it's terminated because the time has passed for it. So that is the lapse of time. So when time passes for an offer can be terminated. Then we have destruction of subject matter. Uh, it is the expiry of item, for instance, that is destruction of subject matter. When an item being offered has expired, the offer can be terminated. Then there's date of either parties. Of course, you cannot continue with an offer when either parties that are involved in the offer uh, becomes deceased. Then we have rejection by offeree. The offeree is that person to whom the offer is made. So when that person rejects the offer, then the offer can be terminated. Then we have acceptance by offeree. So when the offeree accepts that offer, the offer can also be terminated. Then we have counter offer by offeree. With counter offer, how this happens is that, let's say I make an offer to someone to say, I'm selling my car and I want 50,000 kwacha for it. Then the offeree is that person to whom I've made that offer for selling the car. So that person will say, okay, instead of 50,000 kwacha, I have a 45,000 kwacha. So that is how counter offer happens. The offeree counter offers for that offer that I've made. Okay, then the offer can be terminated. Then we have revocation by offer. So when the offer revokes the offer, it can be terminated. Then we have supervening illegality. When there's some illegality in that offer that has been made, then the offer can also be terminated. So these are the conditions under which an offer can be terminated. Okay. Then the next item we'll look at under the elements, which are the essential elements of a contract, is acceptance. That is the second one. Okay. So acceptance is a final and unqualified expression of assent to the terms of an offer. Mutual assent should be reached between the parties in the contract. When we say mutual assent, we mean there should be meeting of minds. Okay. Acceptance has no legal effect until it is communicated to the offer. Okay. Let's take, for instance, the example I gave of me selling a car to someone. Then if that person accepts that offer, without the counter offer, of course, when that person accepts that offer to buy my car for the price that I mentioned, the price I stated, which is 50,000 kwacha, when that person agrees to buy the car, he has to communicate to me for acceptance to take place. So that person has to communicate back to me to say, okay, I'll get your car for that price which you've mentioned. So acceptance has no legal effect until it is communicated to the offer. Okay, so that is what that means. Okay. Then the third element we'll look at is contractual intention. Okay, the intention to create legal relationship. So how that happens is through commercial agreement as well as social agreement. In commercial agreement, it is presumed that parties intend to be legally bound unless the parties expressly state the opposite. Okay. We have a case here in Rose and Frank Company versus Junior Crampton Bros Limited. An agreement between two business parties was not enforced because it contained an honor clause, which is the parties stated not to be enforced by the court. Okay. Then social agreement, in contrast, domestic and social agreements such as those between children and parents are not typically unenforceable on the basis of public policy. Okay, so we have another case here, Balfour versus Balfour, where a husband agreed to give his wife 30 euros a month, while every month, of course, while he was away from home. But the court refused to enforce the agreement when the husband stopped paying. Okay, so that is with the social agreement. Then next on the list is consideration. So let us look at what consideration is first of all. Consideration is something of value which is given by a promise, which is given for a promise, sorry, and is required in order to make the promise enforceable as a contract. Each part to the contract must receive something of value for consideration to take place. Okay. So for example, payment by a buyer is consideration for the seller's promise to deliver goods, and delivery of goods is consideration for the buyer's promise to pay. Okay, so that is how consideration happens. So there are two types of consideration. We have executed consideration as a contract and executory consideration as a contract. Executed involves an act that comes as a result of a promise, and this involves the complete performance of either sides of the bargain. Okay, so when the contract is performed completely of either parties of the bargain, then that is considered to be executed consideration. Then with executory consideration, this is consideration in which either parties have agreed, but neither of them has actually performed. So in executory consideration, both parties, they just agree, but neither of them um, actually performs what is required of them, what they are bound to do, they do not perform. in executory consideration. Okay. Then let us look at the legal maxims that apply to consideration. So when we say legal maxims that apply to consideration, what this simply means is the rules that apply to consideration, the legal rules that apply to consideration. So we have number one, it should be real. Consideration should be real. It should not be based on pre-existing duties. Next, consideration must move from the promise. Next is past consideration is not good consideration. Then the last is consideration given must be sufficient and not always adequate. Okay, so we'll look at these legal rules one by one. So the first rule is consideration, it should be real. Consideration should be real. Okay, so we have a case here in a white versus blue, a case for which was in 1853. So a son sued his father's executor, claiming that the father had agreed to pay him money in exchange for a promise to cease complaining that he was not treated well as his brother. Okay. Among other considerations, it was held to be insufficient consideration in that it was no more than a promise, not above his father. Okay, so consideration should be real. So this case here that we have, it was held to be insufficient consideration. Okay, so consideration has to be real. That is one of the legal rules that apply to consideration. Then the next is not based on pre-existing duties. Consideration is not based on pre-existing duties. So it must not be something that the promisor is already bound to do, not based on pre-existing duties. So it should not be something that the promisor is already bound to do. It must not be a form of a public duty, such as those duties that you are required by law. Okay, so consideration must move from the promisee is the next. A person may not enforce a promise if consideration for it was supplied wholly by some other person. It means that only a person who can sue on a contract is that person who paid the price. Okay, so for instance, if Grace orders a bottle of Coca-Cola for Nancy, Nancy may not sue the third party for delivery failure, although although she happens to be the beneficiary. Okay, so consideration must not move from the promisee. Okay, the person who orders the bottle is Grace, and Nancy is the beneficiary, but Nancy cannot sue the third party for delivery or for delivery failure, although she happens to be the beneficiary. Okay, so that is consideration must move from the promisee. Okay, then we have past consideration is not good consideration. Consideration is past when a promise has been given or executed before and independently of the other promise in sorry about that, guys. We have a case here in R.E. McCarty case, a case of 1951. The occupant of a house did some improvements to it at the cost of 488 euros. After the works, the beneficial owner agreed to pay the amount, which is the 488 euros, in consideration of the said works, but did fail instead, so the payment was not made. Okay, so it was held and claim overruled. Past consideration is not good consideration. Then the next is consideration must be sufficient, not always adequate. Okay. So that is peppercorn rule. Nominal consideration is sufficient. Okay. So that is about consideration. Then we have next item here, terms and conditions of a contract. Terms and conditions of a contract. So we have warranties as well as conditions. Warranties as well as conditions. Okay. So warranties, these are secondary terms and conditions. If breached, may lead to claim of damage only. So if a warranty is breached, it only leads to claim for the damage that has been made because it's a secondary term as well as a condition. Then we have conditions as terms and conditions of a contract. Conditions are primary terms and conditions which, if breached, makes contract repudiated. Okay, so when a condition is breached, it makes a contract repudiated. Okay. The next item we'll look at are the factors that affect terms of contract. The factors that affect terms of contract. So number one, we have duress. Then we have undue influence. Then we have mistake. Then we have misrepresentation. And lastly, we have illegality. So we'll start by looking at duress. We'll look at those one by one in detail, starting with duress. Okay. So duress, um, mutual assent is one of the legal requirements to make a contract valid. So for a contract to be valid, there must be that meeting of minds from both parties. Okay, their minds have to meet for their contract to be valid. Contrary to mutual assent, would make a contract voidable at the instance of one party. Okay, duress is basically attributed to actual threat or threats to harm another party. The effect of duress is that one party to the contract just submits to terms of the contract and does not consent voluntarily. Okay, so that is with duress. Then undue influence. Some social relationships may influence our decisions and change our free will. The influence of social, political, and economical statuses in contracts may vitiate it at the instance of affected party. So where domination is proved, the court will set aside in favor of the weak party. Okay. Imagine having a contract with someone of a high political status. Okay. You might find that there is no mutual understanding between the two. So there become undue influence in such a contract because of the high political status that one individual has. So in such a contract, where dominated is proven, where domination, is proven, the court will set aside in favor of the weak party because the other party has so much undue influence. Okay, so that is how undue influence applies, and that is how undue influence affects the terms of the contract. Okay, because someone has high political status, they might think they can just step on the other person and just do what they want in the contract. Okay, so that is how undue influence affects the terms of the contract. Okay, then next we have is mistake. A contract may be void or voidable if a mistake has occurred. If a contract is void, then it is so ab initio. from the beginning as if the contract was never made. So when it's void, it's like it was never put in place in the first place. In such a case, no obligation will arise under it. Alternatively, if the contract is voidable, the contract will have been valid from the start and obligations may arise under it despite the mistake. Okay, so mistake can be classified um, into three different forms, which are namely unilateral mistake, mutual mistake, and lastly, common mistake. So those are the three classifications of a mistake. We have unilateral mistake, we have a mutual mistake, and lastly, a common mistake. Okay. So with unilateral mistake, um, this is a mistake which occurs when only one party is mistaken. So in a contract, uh, it involves an agreement between two parties or more. So when one of the parties, let's say in a contract that involves two parties, when only one party is mistaken, that is when unilateral mistake occurs. Okay. Then with a mutual mistake, this is when both parties fail to understand each other on the terms of the contract. So in a contract where the terms are failed to be understood by both parties that are involved in the contract, that contract is said such a mistake, sorry, is said to be a mutual mistake because both parties have failed to understand each other on the terms that are involved in that agreement they've come into. Okay. Then with a common mistake, this is where both parties make the same error relating to a fundamental fact. Okay. With a common mistake, just from the word common, this is where both the parties that are involved in the agreement make the same mistake relating to a fundamental fact. So that is it with mistake. Okay. Then now we look at misrepresentation. Misrepresentation. Okay. Misrepresentation is a false statement of fact made by one party to another, whilst not um, a term of the contract includes the other party to enter into the contract. Okay. So conditions of misrepresentation, we have three conditions here. Number one is the fraudulent misrepresentation. Then we have negligent as a condition of misrepresentation. Then lastly, we have innocent. Okay. So with fraudulent condition of misrepresentation, this is made knowingly, okay, without belief in its truth or recklessly, okay. So the misrepresentation that is made knowingly, this is made on purpose because let's say if two parties are involved in a contract, then one party uh, misrepresents um, the other party fraudulently. This is a misrepresentation that is made knowingly without belief in its truth or accuracy. Okay. Then we have the negligent, which is made by a person who had no reasonable grounds to believe that was true. Okay. So just from the word negligent, this is made by a person who had no reasonable grounds to believe that was true. Okay. Then lastly, we have the innocent, which is made in the wholly innocent belief that it was true. So with this misrepresentation, uh, the individual who makes such a representation is someone who who doesn't make it on purpose, like with the fraudulent one, where the person makes a misrepresentation knowing that um, it is a misrepresentation. Okay, so this is made wholly innocent. Okay, so that is with misrepresentation, the conditions of misrepresentation. Okay, so that is all with Unit 1, Business Law. Thank you so much.